The landscape is shifting beneath our feet, and if you or someone you care about is navigating the immigration court system right now, I need you to understand something critical. February 2026 has brought changes to the legal process itself, changes that affect your right to appeal, your timeline to respond, and ultimately, your ability to stay in this country. My name doesn't matter today. What matters is that you understand how the system has changed and what you must do to protect yourself. This is not about fear. This is about clarity. This is about knowing the rules of the game when the rules themselves have been rewritten in the middle of play. Before we go any further, let me be clear about what this video is and what it is not. I am providing you with information based on publicly available federal rules, executive orders, and legal developments as of February 2026. This is not legal advice tailored to your individual situation. Immigration law is complex, and every case is unique. If you are in removal proceedings, if you have a hearing scheduled, if you are waiting on an appeal, you need to speak with a qualified immigration attorney who can review your specific circumstances. This video is educational. It is meant to help you ask the right questions and understand the broader legal environment, but it cannot replace the guidance of a lawyer who knows your case. With that said, let's talk about what has happened and why it matters so deeply to so many people right now. On February 6, 2026, the Department of Justice issued what is called an interim final rule. Now, that phrase might sound bureaucratic and distant, but what it means in practice is profound. This rule fundamentally changed how appeals work in immigration court. For decades, if an immigration judge made a decision against you, you had 30 days to file an appeal to the Board of Immigration Appeals, which we call the BIA. 30 days gave you time to gather documents, consult with a lawyer, prepare your arguments, and submit a thorough appeal. That window has now been cut to just 10 days. 10 days from the date of the judge's decision. 10 days to file, or your right to appeal is gone. This is a fundamental change in how the courts operate, and it places an enormous burden on individuals who are already under incredible stress. But the change goes even deeper than the timeline. The interim final rule also instructs the Board of Immigration Appeals to use what is called summary dismissal far more aggressively. In plain terms, this means that the board can now reject your appeal without a full review, without detailed written reasoning, and without giving your case the kind of careful consideration that used to be standard. The default position has shifted. Instead of the system presuming that your appeal deserves a hearing, the system now presumes that most appeals can be dismissed quickly, especially if the board believes the immigration judge's decision was reasonable, even if you disagree. The burden is now on you to prove, in just 10 days, that your appeal is not only valid, but exceptional enough to warrant full consideration. That is an extraordinarily high bar. This change did not happen in a vacuum. It is part of a broader strategy outlined in Executive Order 14385, which was also signed on February 6, 2026. This executive order is titled Protecting the National Security and Welfare from Criminal Actors, and while that title focuses on criminal enforcement, the practical effect of the order extends to all removal proceedings. The order directs federal agencies to prioritize mass removals, to streamline deportation processes, and to eliminate what the administration views as unnecessary delays in the immigration court system. The language is clear. The goal is speed. The goal is efficiency. And in pursuit of that goal, many of the procedural protections that used to slow down the system, protections that gave individuals time to build their cases, are being stripped away. One of the most significant shifts we are seeing is the expansion of what is called expedited removal. Traditionally, expedited removal was used for individuals apprehended at the border who had no legal status and no pending claims. But under the current directives, expedited removal is being applied more broadly. Immigration and Customs Enforcement, known as ICE, is now using expedited removal for individuals who have been in the United States for years, who may have pending applications, who may have U.S. citizen children, but who fall into certain enforcement priorities. Once you are placed into expedited removal, your options are extremely limited. You do not get a full hearing before an immigration judge. You do not get 30 days to appeal. You do not get the same procedural rights. Instead, you are processed quickly, often within days, and removed from the country unless you can demonstrate an immediate fear of persecution that qualifies you for asylum screening. Even then, the standards have tightened, and the burden of proof is on you to establish credible fear in a single interview, often without legal representation. Now, let me address something that has caused a great deal of confusion and concern. There have been reports, and they are accurate, that the federal government has deployed military lawyers to serve as temporary immigration judges. These are not civilian judges with years of experience in immigration law. These are military attorneys, often judge advocate generals or JAGs, who have been reassigned to immigration courts to help clear the massive backlog of cases. The intention, according to the Department of Justice, is to speed up hearings and process cases more efficiently. But the practical effect is that many individuals are now appearing before judges who do not have the same depth of experience in the nuances of asylum law, withholding of removal, or cancellation of removal. These judges are under pressure to move cases quickly. They are operating in an environment where the institutional expectation is to deny and remove rather than to deliberate and grant relief. I am not saying that these judges are acting in bad faith. I am saying that the system they are operating within is designed for speed, not for careful consideration. Let me also talk about temporary protected status, or TPS, because this is another area where we are seeing rapid change. On February 6, 2026, the administration confirmed that TPS for Somalia will end on March 17, 2026. This is not just about Somalia. This is a signal. For years, TPS was treated as a semi-permanent status for individuals from countries experiencing armed conflict, environmental disasters, or other extraordinary conditions. People from El Salvador, Honduras, Haiti, Venezuela, and other countries have lived in the United States under TPS for decades, building lives, raising children, paying taxes. But the current administration views TPS as a temporary program that has been abused. The policy now is to terminate TPS designations and to require individuals to either adjust to another legal status or face removal. If you have TPS, if someone in your family has TPS, you need to understand that this status is no longer stable. You need to explore other options, whether that is asylum, adjustment of status through a family member, or other forms of relief. You cannot assume that your TPS will be renewed. You cannot wait until the last minute. So what does all of this mean for you? It means that the initial hearing with an immigration judge is now the most critical moment in your case. It used to be that if you lost at the first hearing, you had time to appeal, time to gather evidence, time to find a better lawyer. That safety net is gone. If you walk into that courtroom unprepared, if you do not have a lawyer, if you do not have your documents organized, if you cannot articulate your claim clearly and convincingly, you will lose. And once you lose, you have 10 days to file an appeal, and even if you file that appeal, the chances of the Board of Immigration Appeals giving it serious consideration are slim. The system is designed now to affirm the immigration judge's decision quickly and move on to the next case. This is why I cannot stress enough the importance of having legal representation. I know that immigration lawyers are expensive. I know that many families are struggling financially, but the cost of not having a lawyer is deportation. It is separation from your children. It is losing everything you have built here. There are non-profit organizations, legal aid societies, and pro bono programs that offer free or low-cost representation. You need to seek them out. You need to call every number, knock on every door, and exhaust every option. Do not go into immigration court alone. Do not rely on a notary public who is not a lawyer. Do not trust someone who promises you a green card for a fee but cannot explain the legal basis for that promise. You need a real attorney, someone licensed to practice immigration law, someone who understands the new rules and knows how to fight within this system. There is one more thing I want to address, and that is the role of federal circuit courts. Even though the Board of Immigration Appeals is now dismissing cases more quickly, you still have the right to petition a federal circuit court for review. This is a higher level of appeal, and it is more expensive, and it requires a lawyer who is experienced in federal litigation. But it is an option. In some cases, you can also request a stay of removal while your federal case is pending. A stay is a court order that temporarily stops your deportation while the legal process continues. Federal courts are not bound by the same pressures that immigration courts are facing right now. They operate independently, and while they are not immigration experts, They can review whether the immigration judge or the Board of Immigration Appeals violated your constitutional rights or failed to follow the law. This is not an easy path. It is not guaranteed. But it is a path, and in some cases, it is the only path left. I want to end by acknowledging the weight of what we are discussing here. These are not abstract legal concepts. These are changes that affect real families, real children, real lives. The system is moving faster, the protections are thinner, and the margin for error is smaller than it has ever been. But knowledge is power. Understanding how the system works, understanding what has changed, understanding what your rights are and what your options are, that is your first line of defense. The landscape has shifted beneath our feet. Yes, but you are not powerless. You can prepare, you can find help, you can fight. And while these rules are strict, understanding them is your first line of defense. If you found this information helpful, please share it with anyone who might need it. Leave a comment below if you have questions or if there are other topics you want me to cover. And remember, this is not the end of the conversation. This is the beginning of understanding what we are facing and how we move forward together.